Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us estate planning probate lawyer, David Pyke from Pyke & Associates. Welcome, David.
Good morning, Melinda.
I'm so glad you're here.
Well, thank you.
Well, let's talk about where we intersect.
All right. Fantastic.
We intersect, I know, in the marital property agreement world.
Correct.
And the common person thinks of it as a prenup or a postnup.
Right.
But you prefer marital property.
I like calling them marital property agreements, so it doesn't sound, people come in with, prenup, that's unfair.
Right.
Marital property agreement can be totally fair.
That's true.
So, yeah.
And that's one thing I think people don't understand is they'll call and say, I want a prenup. And I'll say, well, what do you want it to say? Or what is your goal? And they say, well, I don't know. I just want a prenup. They think that alone means something. True.
Right. And it doesn't. So we do have people that want to get an agreement before marriage and have clear rules. And it's, but that's a common thing in a second marriage, and where the couple is bringing their own assets into the marriage or doing planning. Mm-hmm. That they've started estate planning and they have distinct ideas where each of their properties going, but they don't have rules as to whose property is whose. And that's really all we're usually trying to achieve, is that we don't, because you can have, I say that all marriages end. They do. All marriages end. Divorce or death and the legal ramifications are the same. So do you have rules?
Yes, that's right. So one common misunderstanding, and we were talking about this earlier, is it's in my name.
Yeah. That's community property says in your name means nothing.
Right. It means it's ours, not mine.
Yeah. If it was acquired during marriage, it's ours.
Mm-hmm.
And so, it helps for, in talking to clients about this, to think about the bad old days. We lived in a sexist world. The men acquired the assets. The assets would be in the man's name, sometimes required by law to be in the man's name. And it was to protect the helpless little, woman living at home. And that's not our culture anymore necessarily, but that's how it works if you understand. Oh, that's why it doesn't make a difference. That's why we say it doesn't matter how it's named.
Right, because we were trying to, if they did end in death or divorce, allow the woman in our bad old days scenario to have something.
Because the only guarantee for the spouse is that they receive their share of the community property. Mm-hmm. The decedent can gift away all of his property, and if they've done no will and they have children or prior marriage, the spouse gets very little other than her own share of the community property. So most people don't do planning when they have a blended family. The spouse is treated much less favorably than the couple would have decided to do on their own.
Mm-hmm. So we, as divorce lawyers, do not want to mess up people's estate planning. So we often involve the estate planner so that while we're undoing the assets we need to unravel, we're not unraveling ones that they spent a fortune trying to, and with a good planner like yourself, trying to protect something or to get a tax advantage.
Right.
So we have to be cognizant of that. So we're definitely overlap a little bit in our lanes. When people come in for a prenup, one reason they want one is asset protection again, right? And they're thinking, hey, it's a later in life marriage. I've already spent all this time building up all of this estate. She wasn't part of that because we weren't together yet. I was married to someone else. I have children, grown children. Mm-hmm. I don't want my grown children to worry this is a gold digger situation. Mm-hmm. And so what do I do, right?
Yeah.
And what can they do in that circumstance?
Well, so everybody needs their own estate plan.
Mm-hmm.
So a lot of times in a later in life marriage, there is the desire for his assets to go to his heirs, her assets to go to her heirs, and drafting a will is great. Okay, doing you can do a living trust. There's different ways to handle that, but having rules on how you divide the assets. But if we don't have a marital property agreement, then we don't have anything that says whose assets are whom, because how it's named doesn't matter. If it was acquired during marriage and they get confused character assets, and we don't want to have to pull that apart. So when couples come to us and say, we have separate goals for our assets, but they don't have a dispute. This is not
they're on the same page.
They're on the same page. We just say, hey, let's make the rules clear.
Yes.
So that your kids don't fight with his heirs or your surviving spouse.
Let's say that they've done no planning and they do not have a marital property agreement. And my original scenario where...
Ka-ching, ka-ching. Okay. No. Okay. That's what was happening in my brain.
It's more expensive
It's
later.
more expensive. Yes.
It's better to do planning. Planning is less expensive than waiting till death.
Always.
Trying to sort it out.
Always.
Okay. Let's go back to my scenario where my example guy had earned all this money before he married this lovely woman. And he's thinking, I earned that before. It's my separate property. That's correct. But the growth of it, now he's been married to this lovely lady, let's say 20 years.
Yeah.
What's the growth of it?
The growth of it's community property, unless there's a rule, unless you have a marital property agreement. So that's where it gets confusing. That's where you can have fights. And they're resolvable. I mean, there are rules, as you know, to trace and figure it out, but you're going to pay lawyers, you're going to pay accountants, so there's still going to be gray area.
And 20 years of records. The banks don't have to hold your records for 20 years.
And if you can't prove it, it's community property. It's if you can't prove separate status.
It's the same in a divorce. It's the person who's trying to make the claim for separate property. It's their burden of proof. And if we can't prove it, it's considered community. Very few people, in my experience, are printing out a hard copy of their bank statement or receiving it from the bank and putting it in a box and saving it for 20 years.
Really? Okay.
People don't do that anymore.
I'm married to an accountant. We definitely do that.
Oh, well, I like it when people do it because then I can trace if we need to. But very few people do it. So much is coming electronically now. They never receive it in a hard copy, or they shred and they're like, hey, the IRS says 7 years or whatever, shred.
I mean, but some of it's so much easier now, though, if you think about it, because you're receiving it digitally.
Just save it digitally.
Save it digitally, and they give away space so freely for Dropbox or whatever service you use.
It's not that big of a deal to keep it.
You never have to purge it.
Yeah.
Just save it once, forget about it. It's always there. And make sure your heirs have your passwords.
Oh, that's the other thing, right? And then no one can find it, so it doesn't matter.
If you can't find it, it doesn't exist.
That's the truth. Okay, let's talk about something else. We put in our letter when people get divorced, we say, hey, go update your wills. You just got divorced. Most likely, your will left maybe everything to your spouse who you just divorced. And maybe you want that now, maybe you don't. But let's say I want it. Let's say I divorced and I want to leave everything to my spouse because we have minor children together in my little made-up scenario. Is it fine to do nothing?
No, it's never fine to do nothing because the law says the divorce voids any gifts in a will. And it's done by treating that person as having predeceased. So you read the will as if that spouse had predeceased.
Some people would like that idea.
And sometimes we wish them dead. Sometimes that means it works, but sometimes it doesn't. If you want the spouse to have them, usually that's not what they do. But they may want to have a trust for their children.
Yes.
With the spouse as the trustee. And if you haven't done that, if you hadn't reaffirmed that after divorce, again, that's void too. The spouse couldn't serve as trustee. So you need to do intentional planning. It almost always, it would rarely be a case where a divorce doesn't mean you don't need to redo your documents. The bigger thing, because it's not as curable, is things like 401k plans, IRAs, things with beneficiary designations, especially 401k plans that are governed by federal law. State law says the gifts to a spouse are voided by the divorce. not federal law. If you leave your spouse on your 401k, your ex-spouse, you don't revise it, it is the money of the ex-spouse. No relief for your children, your heirs, your executor. It's done. The 401k administrator, the ERISA plan administrator will write the check to the ex-spouse.
Oh my gosh, that's important.
Yeah.
So when my mother passed, we did not have to, we probated because we had to transfer property like real estate, but we didn't think we were going to have to set up a whole estate.
Yeah.
With the IRS because it was fairly simple. But my dad had predeceased my mom by 14 years, and she had one retirement account that was still with the retirement people. It wasn't even that big, left to my father. And it had no, sometimes it'll say alternative people did not have alternative. So we had to set up a whole estate just to deal with that one asset.
Right.
Again, more expense.
So you're finished with an estate when there are no assets in the name of the decedent. That's the whole point. The legal part of it sometimes, hopefully, is simple, easy, because you've done good planning.
Yes.
Probate in Texas is not a nasty word. Probate works very well for a lot of people, but then you actually have to do the work. And a lot of times the work is not legal. It's just going to the bank, going to the investment company.
Yes.
If you get a statement that's in a deceased person's name, you haven't done the job. You're not done yet.
I was like, oh, are you kidding? I sent them. I was like, he died. I can prove it.
Yeah.
They don't care.
So I get to be the administrator of an estate right now where the decedent was the administrator of her grandmother's estate.
Oh.
Died decades and decades ago. But we never changed the name. I have to also get appointed for the grandmother's estate.
Oh, my word.
And the mother in between. So having the legal authority, probating the will doesn't finish the process. But it's just business. It's getting around, calling people. It can be a pain. Financial institutions are not easy to deal with.
It's the truth.
They are not easy.
Oh, only thing worse is insurance.
Yes.
Okay, so in family law, as you know, and this also may come up in probate, we have temporary orders. And the court, while the case is pending, will put in many courts in the Dallas-Fort Worth area, we have a standing order that just attaches to our first pleading and has a bunch of prohibitions. And one of the prohibitions is do not change your will. Is that legal or allowed, or can they change their will anyway? The consensus among the probate lawyers and probate judges is that's not legal, which is interesting. That because we cannot enter an order in a guardianship when we found somebody incapacitated. They're incapacitated to handle their financial affairs. The order cannot say they can't make a will. That is not allowed by our statute. And they think it's the opinion of the judges that I've been talking to is that's a constitutional right that a court cannot take away. If a guardianship court can't take it away, we think a family court can take it away. Super interesting.
But I think at minimum, if you're going through a divorce, go ahead and consult with the estate planning attorney. Your life's about to change. Right. And some of it you may be able to change now.
Right. Yes, so that is very interesting. We don't want people to have a situation where it's encouraging bad actions, right? But we want people to be able to make their planning how they really want it to be, which in many cases at divorce, they want to leave it to their children now instead of their spouse.
Right. But don't
Don't leave it to minors.
Don't take your life insurance policy and make your minors beneficiaries. Yeah. Yeah. Again, we get to make nice money off of that. It hurts our soul. All you had to do is name a trustee. You create a will, have a trust. Much better to do that.
And explain why, because a minor doesn't have...
They have no capacity to contract. That means they cannot open a bank account. An insurance company will not issue a check to the minor, and minor is a day short of 18 years old. And therefore, the only way to solve that, if there hasn't been a trust established or a change of beneficiary, is to go to court, create a guardianship, court supervision of that process until that person is not a minor. Usually leads to a court-created management trust. Is that the easiest and least expensive way to handle that? Heck no. No. It's a
plan ahead.
It's solvable, but it's solvable at expense. And ironically, a lot of times, I'm going to put this from the male point of view. It's the man decided he didn't want to leave the money to that woman. Okay. And
that woman he divorced.
That woman he divorced, or she divorced him. And so he wants to leave it to his kids. Who did he not want to manage that money?
That
woman. That's likely who's going to manage the money if you didn't create a trust and pick your own trustee.
Yeah, so you could pick your brother
Absolutely.
or another trusted friend or relative who you would trust, and then that woman would have to deal with the brother.
They'd say, I need money to take care of the children.
Right.
The brother's a reasonable person. You're going to say, yeah, you need money here, there, and everywhere. Yeah. You don't need a pool addition to your house. Maybe that's not what you need.
Because normally it would be kind of some general language about their money for their health, welfare, education.
If we pick a good trustee, we want to give the trustee discretion.
Yes.
Because, you can't say only in good times you can get the money, because unfortunately bad health, bad things happen, and you got to plan for the bad times too.
Tennis shoes, yes. New pool, no.
No. That would be my role if I was the trustee.
Oh, some things are more obvious than others, probably.
Right.
There's probably some gray area.
Yes.
So you serve as a guardian. What's the difference between an executor, which a lot of people are familiar with because it'll name the executor, and a guardian?
So a guardianship is to take care of somebody who is alive but incapacitated.
I see.
And they can't handle their financial or legal affairs. And if the family can't agree on who that will be, if the court is aware of the incapacity, they can't just ignore it. It's not like, oh, well, we're just not going to do anything. They have to appoint a guardian, and sometimes they'll appoint an attorney. They'll appoint an attorney to handle the financial affairs, and usually someone that we call a private professional guardian, an individual who's licensed and trained to make healthcare decisions and living decisions for somebody.
That's sad that that means the family is having a big dispute, probably, right?
It is. Or some, can be a situation, thinking of a case right now, the sole son was not financially honest.
Mm-hmm.
So the court couldn't appoint him.
I see. Yeah. So they're being protective. That's good.
I mean, that's the court's job in that case. So it's protective. Guardianship is very protective. Guardians are bonded. You don't have to worry about a guardian like me stealing your money, because not only would my bond have to pay for that, and the bonding company would sue me, the state bar would take away my law license.
Right.
So it's
not worth it.
Not worth it by a long shot. So it's very protected, but the protection leads to expense. We have to go to the court and ask for permission to do almost anything.
Oh, yeah. And every time you do that, that costs money.
Costs money.
Yeah.
Mm-hmm.
Okay. So let's talk about, I hear people say, oh, I think you should always set up a trust. And then I hear other people say, you don't need a trust. What are you talking about? Is part of estate planning, is there an always or never, or is it an it depends?
It depends. I mean, so with a trust, we're talking about usually a revocable living trust. Mm-hmm. And it is a planning tool that will avoid probate. And in some states, the lawyers almost universally recommend a revocable living trust because probate is bad in those states. Oh. California is one of those. That's just not true in Texas.
I see.
And trusts are more expensive to set up and a little bit more cumbersome to deal with and put more burden on the client. And so sometimes it's the right answer and sometimes it's not. So when we talk to somebody, that's one thing we're trying to figure out. Is this a good solution for you? Is it not a good solution for you? We make recommendations, they make a decision. But someone who tells you everybody always, and the two biggest lies about revocable living trust is it's going to save you taxes and it's going to protect your assets from creditors. You can't just put your assets into a trust and not pay taxes and tell your creditors to blow off. No.
It's not magic.
That would be magic. That would be wonderful. And that's amazing.
Everyone would be doing it every day.
It's amazing what we can do for the beneficiaries of that trust to do exactly those things, to protect the assets. Taxes, forget about it. If someone says there's a way to avoid income taxes, fold up your pocketbook and run. They're probably not telling you the right stuff.
The government is going to get their money.
The income, if there's income, there are taxes.
But there's good tax planning, right?
Absolutely.
Where we can defer certain things or we can take advantage of the rules, but it's not a blanket easy, you stick it in this vehicle and it's magic.
No, it's not magic. It's not magic. Therefore, it's not for everybody.
Right. Is the trust answer subject to people of a certain level of wealth? It would make more sense.
Yes. I mean, if you have extreme wealth, then you need a sophisticated estate tax planning. Extreme wealth now is for a couple $30 million or more.
Yeah.
So this is
not everybody.
It's not most people.
Not most people.
Not most people. And for everybody else, it's more has to do with complexity and character of the assets. Property in multiple states, real property in multiple states. It's easier to handle it with the trust.
I see.
If you got, God bless you, 52 mineral royalty interests that are writing you checks, if you have to transfer those, you want to do it once. So do it once, put it into a trust, and have that trust run for a long time because they're a pain and an expense to transfer. So it's more the character of the asset.
I see. Does it have anything to do with the family dynamic?
Oh, yeah. So the question that you have to politely ask is, well, how crazy is your family?
Are we going to all be fighting or not?
We know there's a little crazy. Okay. But when the family is, it's a little bit difficult to explain in the short format we have here. But if the family has a bad dynamic, a trust is a more robust vehicle to deal with guardianship. You want to avoid guardianship, and it's a more robust vehicle to do that. So yes, those are complexity of assets, type of assets, and family dynamics are usually the reasons that lead to a trust.
What about somebody who, it's not that they're all bickering and it's not that somebody's crazy, but maybe somebody is a little bit, they're not so ill or so they're not incapacitated,
okay,
but they have limited capacity, perhaps. And they could be easily taken advantage of, or that we're not sure if that limited capacity will last. Would that be another reason people might consider?
It might. Of course, then trust is a fairly complex instrument. And, I think some people have powers of attorney, the simple, easy way to deal with incapacity. And I think some people have capacity to execute a power of attorney and may not have capacity to sign a trust. But building checks and balances in your financial life in particular, and one of the ways to do that is have professionals involved in your financial life. If there's somebody, you have a clear-cut banking relationship with an individual, you have an investment advisor. If somebody starts monkeying with your money, they're going to raise alarms. Yes. And often they will be the one who first blows the whistle. And the financial institutions sometimes have to freeze accounts because they're very concerned about what's going on. And they see this. So having someone who's an advocate for you, that's non-legal. That's not legal work. That's just, but we have a lot of people who want to handle everything themselves. And then as their life starts slowing down and maybe their mental health starts slowing down, it's more and more difficult. They have no one to help them.
Yeah, so it's good to have somebody who's kind of can blow the whistle or raise a red flag, whose job is to manage things like that.
Right.
Don't be a control freak. Let somebody help you.
That's good advice for almost everything.
Right. You mentioned powers of attorney.
Mm-hmm.
And I know that when you go to do your estate planning, let's say somebody's never done any and they need to get some basic estate planning, that would typically include some powers of attorney, correct?
You're going to have to run out of our office screaming and not sign powers of attorney at a minimum. I mean, every adult, and adult, I mean 18-year-old and older, needs a power of attorney. My son was going off to college, and I slapped down powers of attorney for him to sign. And he said, I'm an adult. I don't have to sign that. And I said, and I'm your parent, and I don't have to pay your tuition.
Right.
So we worked out the situation. But, you know,
consequences to your actions.
Having the medical power of attorney is particularly important for young people that are leaving home. It's a simple document, but they've designated someone to step in and get their access to their medical records, because a parent is no longer a parent of an 18-year-old.
I think that would shock people. I mean, if their college kid had an accident and is in the hospital, all parents would think, I'm going to go to the hospital and direct that physician. And without that power of attorney,
they don't have the right to.
It's just so shocking. So
yeah,
that is not an expensive thing to put in place.
No.
And there's different types of power of attorney, right?
Right. Generally, there's a medical one, and then there's a financial one, which for some reason we call a durable power of attorney. So,
and they can be the same person or different people.
They can, but you need both. Everybody needs both, unless you literally have no assets. Everybody needs both. If you got a checking account, get a power of attorney. So pick the person you trust.
Yes. And it could be different. You might feel like, hey, in a medical situation, I would want this person.
Right.
But for financial, kind of the organized person in the family, I would want this person.
Yes, you might want the person who's more number oriented and the person who actually has a heart to make those decisions.
And in most cases, you can list an alternative person.
Yeah, we sure like to do that.
In case you forget, it's been in the drawer for years, the first person listed predeceased you.
You want to do that with trust, wills, powers of attorney, to have them be as flexible as possible, that we've thought of alternatives so that it's not anything happens in life requires you to redo your documents. Hopefully, you look at them.
Yeah. How often should somebody review and decide, hey, I should probably review or update? Is it based on time passing or things happening?
Just both. I say look at it every 5 years.
Okay.
Look at your documents. Or in case of a major life change. What's a big major life change, Melinda? It is divorce. Divorce and death, or incapacity. So the two things that happen most commonly are the person that we want to leave our property to has already passed away. Or the person we wanted to run our estate, be the agent, be the trustee, to have these roles, is either not available or not able. Or maybe they were our best friend. Past tense, were our best friend.
Right.
And we need to change that.
They're not the appropriate person now.
Anymore. So those are the circumstances. So if you read the documents and you go, well, this still works, then they're still good.
What if somebody doesn't have anyone, and that's sad, but some people, they just don't have family and they don't have an appropriate friend? Who would they list?
It's tough because anytime you're appointing somebody in these type of documents, you're really asking them to handle your matters without court supervision. You're trying to avoid that expense. Well, that means you have to have somebody you trust.
Right.
If you have a lot of money, there are banks that will be happy to be your trustee, but most people don't like that. And you really have to have a substantial amount of free cash,
before
investable assets. They don't want to handle someone with a $200,000 bank account in a home.
Right.
That's just not in their wheelhouse. It's not their expertise. So sometimes they have to think really, really hard. Do a pact with their close friend. I'll do it for you. You do it for me.
Yeah.
So yesterday's consultation for me literally was go home, think about these answers. Let's come back and talk again. They're
I had a client once who wanted me to be executor, and I said, "Oh, usually that's a family member," and she had minor children. Usually, and she'd gotten divorced. Usually, that's a family member or a friend. And she said, "I really don't have anyone."
right.
And so I was like, "Okay." And I just noticed on Facebook her children are adults.
All right. Time to call her up. Call her up.
That's right.
Yeah. Because it's a job. Interestingly, we get disputes in estates. Who's going to run the estate? And I'm saying to my client who's not happy, okay, but you understand this is a job.
Yeah. Yeah.
And depending on how messy the estate is, it can be a big job.
Yes.
The legal part may be easy, but the financial part may not be.
Yeah. It's not fun.
It's never fun.
Okay. Well, our time is up.
Oh, fantastic.
But I want people to know how to find you. Where do you practice and what area do you cover?
So we are active in all of the counties of the Metroplex. Most people, our office is in North Dallas, so most people who do a planning want to be somewhere within 10 miles of that, to come into our office. But for probate and guardianship and court actions, they just need to be in a surrounding county. And the probate is where the person was living. So you may be here, but if your parent was in Tarrant County, that's where we're going.
I see.
Yeah.
Thank you so much.
Well, Melinda, my pleasure.
So helpful.
All right.
Thank you all so much for watching. We have learned a lot, and I think the bottom line is plan ahead. It's less expensive for you and your heirs to plan ahead. It's not fun. Nobody wants to think about dying, but highly recommend make it a priority. Plan ahead, and then look at your planning every 5 years. Thanks for tuning in, and we'll see you next time on the Melinda Eitzen Show.